Okay, here is the beginning of our Chapter 9 PowerPoint. The subject of this chapter is what happens before the trial in civil litigation. We have a course, which is LGLA 1342, and another course, which is LGLA 1343, that talk about federal civil litigation and Texas civil litigation. So there's a lot you can do with this topic. We're just kind of touching on it in this course to kind of introduce some concepts. So let's get started. In this chapter, we cover the steps involved in the civil litigation process and the tasks that paralegals commonly perform during the pre-trial phase. Again, we have another chapter that we'll discuss during the trial process. We're going to talk about the litigation file. What is it? What is its purpose? What does it contain? And how is it commonly organized, maintained, and reviewed? We're also going to talk about changes that have happened and because of the technological advances in the last 20 years or so. We'll talk about how a lawsuit begins and what documents are typically filed during the pleading stage of a lawsuit. That's the first stage, at the time when the initial documents are filed. And then, of course, we'll talk about the subsequent stages. We'll talk about pre-trial motions. We'll talk about discovery. We'll talk about the type of information that is exchanged and how those tools are used. Discovery isn't an especially glamorous part of the litigation process, but it is really oftentimes where cases are lost or won. They're certainly where a lot of the time of the case are spent and a lot of the cost of cases occur. So it's a really important topic that we will talk about fairly extensively in this course and even more extensively when you get to 1342 and 1343. You can see this chapter is correlated to your study guide, so if you don't already have yours up, you may want to pause this presentation to pull up your study guide, and we'll get started. So what is a paralegal's role in trial preparation? Well, there are some common things paralegals do. Of course, one is going to be legal research, which is our first bullet to add. We're going to talk about also gathering evidence. This can be facts, it can be witness statements, it can be lots of different items. It can be arranging for demonstrative evidence to be prepared. Paralegals often maintain files. Now, sometimes that is done by the attorney himself or herself or by a secretarial person or some other person in an administrative role. It is my experience, though, most commonly most of the work of file maintenance is done by paralegals. Yes, the secretary may actually put the piece of paper in the file, but the paralegal is likely going to want to make sure that the organization is current, is correct, and nothing is missing, and there's extra copies of the things that extra copies need to exist for. So other than the maybe mechanical task of putting papers in folders, the managing of the file oftentimes falls with the paralegal. And then preparing witnesses. Now, there certainly are paralegals who prepare witnesses, especially the more minor witnesses. But I will tell you more commonly that is a role of an attorney to do. However, it's very helpful to know what's involved in preparing witnesses, and many times paralegals will have a role, perhaps a solo role if it's a minor witness, or a supporting role for more important witnesses in witness prep. We'll talk about the litigation process, what the different stages or phases of litigation are. We'll talk in very general terms about the rules. When we talk about litigation rules, we're really talking about procedural rules. You'll notice in the law that we constantly are making a distinction between procedures and substance. Substantive rules are about what the law says. Procedural rules are about how you go about getting the goodies that the law says or stopping the bad things from happening that the law says shouldn't happen. The main source of litigation rules are going to be the federal rules of civil procedure and the state rules of civil procedure. In Texas, obviously, they're called the Texas rules of civil procedure. There are also criminal rules of criminal procedure, both in the federal system and the state system. Those are procedural rules, and they're important to know about. We talk about those very extensively in the federal civil litigation class. If you want to review those rules, you can find them on Blackboard under web links. Then we'll talk a little bit about forms and a lot about terminology. As you probably already noticed in this course, we spend a lot of time talking about terms and phrases. This course, I think, probably more than anything else, is like a vocabulary course. It's not so much the concepts themselves are hard, but when you're hearing 10 new words thrown at you constantly, it can be daunting to figure out, well, what does that word mean? I know she's already said what that word means, but I've forgotten, and now she's throwing in 3 new words. That can be confusing and daunting, and so keeping up on the vocabulary can be very helpful. You may at times want to pause this presentation to look up a word, to Google it, or to look at the index of the textbook or some resource like that. And of course, I think, as I said throughout, keep in mind that terminology is a big source of questions, especially on my quizzes. So emphasize those words when you're preparing for tests. As you can tell by the title of this course, this chapter really focuses on the pre-trial stages of civil litigation. So we're not going to really take to the trial or to the post-trial activity in this chapter. We'll talk about that in subsequent chapters. Okay, let's talk about civil litigation. By the way, Chapter 12, which most likely we've already covered, will have covered criminal litigation. And there are some parallels, but our system has a lot of differences. So the civil part I'll talk about under the assumption that we haven't talked about criminal for the purposes of this lecture. So when does civil litigation begin? Well, there has to be an event, or at least somebody imagines there's an event that causes a legal claim to arise, at least in the mind of the plaintiff. Usually this is called a cause of action. It can be a car accident, it can be a breach of contract, it can be an employment termination, or it can be something that was supposed to happen but didn't. So sometimes it's a non-event that gives rise to legal action. And of course, it can be a matter of dispute. The plaintiff feels that an event happened, but maybe the defendant doesn't agree that that event happened or doesn't feel that he or she is responsible for that event. So certainly, we're looking at this from the perspective of the plaintiff when we use these terms. It may end before trial if the parties agree to a pretrial settlement or if the case is dismissed. We know statistically that the vast majority of cases do not go to trial. Only about 5, maybe 10% of cases that even result in the filing of a lawsuit will ultimately result in a jury verdict. The vast majority of cases are going to be settled through pretrial settlement, where the parties voluntarily decide that there's some solution to their problem short of litigation. A smaller percentage of cases will be dismissed. This is something that the trial judge would do. He or she would say, well, based upon the motion filed by either the plaintiff or defendant, although usually it is the defendant, there is no need to take this case forward, that we're going to end the case here. So, while my statement says may end before trial, that's a pretty common thing. I would say a better way of phrasing that might be probably will end before trial, because the parties probably will agree to a pretrial settlement, and there's always the possibility that the case may be dismissed by the judge. Let's go to bullet 3. Of course, if it doesn't settle or isn't dismissed, it will proceed to trial, and that will result likely in a judgment. Judgment, let me first of all point out one thing about the word judgment. You notice in the word judgment there's only one E. Sometimes people write the word judgment with 2 E's. They'll put in E between the G and the M. In other words, they'll take the word judge and not drop that final E before they add the suffix ment. I did a little bit of searching about that custom, and it appears that in England, especially with respect to legal matters, they also write judgment the way that we do. But when British English speakers write the word judgment in other contexts, they many times will have 2 E's in it. In American English, it is more common to only use the 1 E in non-legal contexts. But having both E's is okay, although not as common as it is in British English. However, in legal matters in the United States, to put that first E in after the G is really kind of a faux pas. It shows a sloppiness or a lack of understanding of terminology. So please don't do that. The spell check is probably not going to fuss at you if you put that first E in, but it does mark you kind of as an amateur. So for the legal perspective, only have that E after the M. But let me go back substantively to a discussion of judgment. Judgment is the end of the case. It's the judgment. It's after the jury has rendered a verdict, it's the judge saying that this is the result of the case. It's the conclusion of the case. Certainly, appeals are still possible, but the case is over, at least from the trial perspective. As already discussed, there are procedural requirements. If we're in federal court, there are going to be the federal rules of civil procedure. If we're in state court in Texas, it'll be the Texas rules of civil procedure. These are like the rules in a football game or a soccer game. It tells people, how many innings there are going to be, or quarters, or how many days you have to file something. They are the outlines of the game, and they provide the opportunity for some strategy and some reflection. So knowing the rules well gives you more tools to decide how you're going to maximize your chances for a good result and minimize the chances for the other side having a good result. Here's an example of a timeline. You can see at the top we have an event. It says accident, breach of contract, or other event. I might call that a cause of action. That's what motivates the plaintiff to want to look into litigation. And then the party, most often the plaintiff at this stage, is going to find an attorney. There's going to be an initial client interview. There's probably going to be a signing of a retainer agreement, which is between the attorney and the client, saying, hey, I'm going to represent you, and this is what our fee structure is going to be like. The paralegal may be present for these initial client consultations, or may not be, depending upon the circumstances. Then there's going to be an informal investigation. Actually, there may actually be an informal investigation before the attorney has decided whether to take on the case. It's often the case that paralegals are very involved in this informal investigation. Keep in mind that discovery rules are not in play here because a lawsuit has not been filed. So the tools that the paralegal or whomever's conducting the investigation have are just the same avenues that a private citizen would have. After the informal investigation and after the attorney is persuaded that there is no ethical problems with proceeding with the lawsuit, then a complaint will be filed. Complaint is the term that is used in federal court. It is also used in some state courts. In Texas, we use the term petition instead. But it means the same thing. It's when you explain what your beef is, what your complaint is, with what the other side has done. Of course, the term petition means you're petitioning the court for some type of redress or solution to your problem. While the attorney has to sign the complaint, it is very common for the paralegal to draft it, and after the attorney has signed it, to either file it himself or herself, meaning the paralegal filing it himself or herself, or probably more commonly having a courier deliver it, especially if you're not that close to the courthouse. Now, prior to the complaint being filed, many times the defendant will be very aware that a lawsuit is likely to happen. For one thing, the plaintiff's attorney may have contacted the defendant to say, we're going to sue you unless you settle. And when the defendant elects not to settle is when the complaint is actually filed. Or the defendant may simply be aware that because of some behavior they've engaged in, it seems quite likely that a lawsuit will proceed. So very likely the defendant, or very possibly the defendant, will know before the complaint is filed, but sometimes the defendant doesn't know. The defendant's first knowledge may be being served by the complaint. If the defendant does not waive service, both the complaint and the defendant needs to be served on the defendant. He is entitled, or she is entitled, to actually receiving the complaint and the summons. Another name for the summons in Texas State Court is citation. After receiving the complaint, the defendant is likely to file what's called an answer, or possibly a motion. Many times that is a motion to dismiss, although it can be something else. After let's assume the motion to dismiss, if one filed, isn't successful, and the defendant ultimately files an answer. Well, we're now done, usually, with the pleading part of the lawsuit. The pleading phase, again, is the first phase. Now we're ready for the discovery phase. There are 5 common discovery tools. The first is interrogatories. Then there's requests for production. These are typically documents, but they can be also electronic data. Depositions, which are oral questions that are asked of various deponents. Then there can be requests for medical or physical examinations. And finally, there can be requests for admissions. Paralegals are typically very involved in preparing those types of questions for the other side and responding to the other side's questions. Let me backtrack for a second and go back to the answer. Let's say you are a paralegal and you work on the defense side, you are very likely to be involved in drafting the answer. But just like the complaint, ultimately the attorney is going to need to sign the answer. And nowadays, particularly in federal court, but to some degree in state court, though that answer is going to need to be filed and likely filed electronically. And paralegals are oftentimes involved in knowing the systems well enough to be successful at filing something like that electronically. So now let's go. We talked about the discovery phase. It's just one box in this picture, but it's a very lengthy process. Easily the longest part of a trial or a litigation case. Okay, let's go now to a time which is a pretrial motion time. The most common motion to be filed at this time is a motion for summary judgment. This is almost always something that the defendant would file, although there are occasional cases where the plaintiff might file. And this is the defendant saying, hey, we've finished discovery. I know everything they've got, and it's not enough. The facts that they are saying are sufficient, just aren't sufficient for them to have a legal basis for their claim. So, Your Honor, please just dismiss this lawsuit and save all of us some time and effort, because we know they're going to lose. Might as well get it over with now. That's the idea. And you can't really file a motion for summary judgment. Well, you can file at the end of discovery, but you can't really file in the middle of discovery because you don't know all of the facts that the other side has. So it's premature until you've learned that, because then you're not in a position to say, this is what they got, and this isn't enough. After the motion for summary judgment is considered, and let's say it's rejected, you're going to get ready for that pretrial conference. And this is the time where the parties get together and with the judge and discuss how the trial is going to proceed. Then, of course, there will be the actual trial that's going to start. There's going to be a jury selection process, which is oftentimes called voir dire. That is spelled V-O-I-R-D-I-R-E. These are 2 French words, and they correctly pronounce voir dire, but in Texas we pronounce them voir dire, so a little trivia about pronunciation. We think about terms in the law coming from Latin, and many of them do. But also keep in mind that after 1066, when William the Conqueror invaded Great Britain, many of the wealthiest people and many of the best educated people in England had French ancestry and spoke Norman French. So we will find in our legal system some French terms, and they may not be modern French, but the terms that have ties to medieval French appear in the language, and voir dire is one of those examples. And then, of course, after the jury is selected, the trial begins, and there's lots of different steps to the trial, but we'll talk about that later. After the trial and the jury verdict, there will be post-trial motions, and there can even be an appeal. Appeal doesn't happen in every case, but whether it happens or not, let's assume that the plaintiff was successful, well, the plaintiff is going to want to enforce and collect the judgment. We'll talk about some of that as we go forward. Okay, we're up to the preliminaries, the initial client interview. This is usually conducted by the attorney because it involves elements of the practice of law. The paralegal, however, often attends and assists, maybe by taking notes, maybe by asking follow-up questions. Those are common roles for the paralegal to have. Now, I will tell you that it is true that the attorney usually conducts this meeting, but it is by no means unheard of for the paralegal to be that initial screener. This is especially true in plaintiff-based law firms. It may well be that a law firm finds that only 5 or 10 or 20% of the potential clients who walk through the door have a claim that is really worth investment on the part of the law firm in. Keep in mind that most plaintiffs are going to have a contingency fee arrangement with their law firm. So if the case isn't any good, the law firm obviously isn't going to be interested in spending time developing a case that's not going to result in an ultimate payoff. So the paralegal may well screen the cases and may narrow the cases down to the top 20 or 30% and then allow the attorney to figure out which one of those are most likely to be successful. So after the initial client interview, then there will likely be a preliminary investigation where the paralegal is developing the facts of the case, getting the police report, finding out where the intersection was. This is likely to be an extensive interview with the client, but there may be medical records or other items that either the client has or that the client knows about so that you can research how to get those. And, of course, the litigation file has to be created. As I said before, these are often created by the paralegal, but even if they're not created by the paralegal, they're oftentimes maintained by the paralegal. Offices vary in how they organize these files. Some offices have a very firm and strict method, and everyone's litigation files are going to be identical. Some, there's a little bit more flexibility to work with. So be sure that you know what kind of office you're in and what the standards are in that situation. Even if there are maybe less formal standards, it's a good idea to learn about the practices of the attorney with whom you're working. I once practiced law with someone who very much had his own style of how he wanted to maintain his file. He was a very meticulous, detail-oriented person, and he actually maintained his own files and really didn't want the paralegals touching them except to sometimes add documents or things along those lines. That's an unusual rule for an attorney to have, but you'll find people like that. And he would work with paralegals who would work with other attorneys. And so a paralegal who worked with him would have to figure out, hey, this is the type of relationship this attorney wants. I really don't need to have access to the files. It's going to be maintained in his office. He wants them organized in this way. Whereas another attorney may want to have a very different relationship with the file. So be sure to ask questions about things like that and notice kind of the office practices so that you will not assume some things that might not be the case in this new environment that you're in. So let's talk about pleadings. We've already talked about the complaint, which is called the petition. The complaint has 5 technical aspects. It needs to have a caption, which is just the part of the complaint that says what court it's in, what the case number is, what the name of the document is, and who the people are involved, who the parties are involved in litigation. Then there needs to be jurisdictional allegations. We talked about the need for jurisdiction in previous lectures, and every complaint is going to include allegations that tell the court, hey, court, you can hear this case because you have jurisdiction. This section of the complaint is typically at the very beginning. It doesn't have to be, but keep in mind the court's first concern is, do I even have the authority to hear this case? So if you bury that at the end, you won't have kind of satisfied the court's primary concern. So it's best to put in the beginning. It's where everyone expects to find it. After the jurisdictional allegations, you'll usually have what's generally called general allegations. And that is the meat and potatoes of the lawsuit. It's where you tell your story. I was done wrong to. This is what happened. This is why I'm mad. This is going to include factual allegations that may be described as causes of action. Usually they don't have to be. You usually don't have to say there was a breach of contract, which would be the name of the cause of action. You can just describe the facts that would lead someone to conclude that is what you're suing about. But anyway, you're telling your story. After that, you're typically going to want to ask for some type of relief. Hey, I've been done wrong, and this is what I want in exchange. Usually, the plaintiff wants money, but sometimes he or she might want something else. And then there will need to be a signature. If the plaintiff is pro se, meaning representing himself, pro se is spelled P-R-O-S-E, then that plaintiff will sign the document himself or herself. But most of the time, he or she will have an attorney, and that will be the person who signs the complaint. It is not necessary in a complaint that a jury demand be made, but it is very, very common. If a demand for a jury trial is not made by either the plaintiff or the defendant, then the judge will act as the finder of fact. It is even if the plaintiff wants a jury trial, if the plaintiff somehow forgets to make it in the complaint, usually there's an opportunity, maybe for about 2 weeks, for the plaintiff to request through a separate document a jury demand. But it's usually just easier to put it on the complaint, and that is usually where it goes. The complaint needs to follow the applicable rules of court, including local rules. Local rules are really easy to find. You just go to the court, and usually there's going to be a tab that says local rules. And it will also need to follow the time frame that the statute of limitations provides. If the statute of limitations for this for this type of claim is 2 years, and it's been longer than 2 years, yes, you can still file your complaint, but it will be obvious to the defense that it's right for a motion to dismiss the lawsuit. So waiting to file a lawsuit until it's too late is likely going to result in a less than satisfactory outcome for the plaintiff. Then the complaint has to be filed with the court. Now, when I say filed with the court, I really mean filed in the clerk's office. The clerk is kind of the I don't say secretary, but the file room for the court's office. So you don't actually take it to the judge. You don't take it to his or her chambers, although in some courts it's common to send a courtesy copy to the judge's chambers. But this is sent to the clerk's office, and it will be stamped, and you'll get a copy. The traditional method of filing is actually have a paper version, to have someone actually come down and stamp it. Complaints can be filed electronically, and nowadays, really the complaint is the last document, or the only document that typically gets filed through paper. The rest of the documents that are put into the file for a particular case are going to be electronic. But the complaint is still more commonly not filed in a paper method. This is an example of a complaint. This is actually filed in federal court. It's not completely typical of the ones we would see in Texas, but you can see the caption is that very top area. Then you can see there are jurisdictional allegations, and then there are the general allegations. You can see in that wherefore paragraph, there's a prayer for relief, then there's a signature, and then there's an affidavit. We usually don't use affidavits in Texas. There are sometimes we do, but they're fairly unusual. And you'll see at the bottom there's a demand for a jury trial. There's a couple of different ways of doing that. This is one of the ways of accomplishing that. Let's talk about service of process. This is the delivery of the summons and the complaint to the defendant. Again, in Texas courts, it can be called the citation and the petition. This is how the defendant officially is informed that he or she has been sued. The defendant must be properly served in order for the court to exercise jurisdiction. If the defendant isn't properly served, then he hasn't been properly notified about the lawsuit, and so it would be wrong for the court to penalize him when he doesn't even know he's being sued. That would violate notions of due process, a constitutional protection. So you can't secretly sue somebody, and then when they don't show up to a trial they don't know about, and then they lose, you go ahead and then take their assets from them. That doesn't meet requirements of due process. There are different methods of service. Most common is probably personal service, but there is also mail service, and there's also service by publication. Depending upon the particulars of the case, one or another method might be appropriate. The plaintiff will file a return of service form with the court after the service has been accomplished. Again, this will be sent to the clerk's office, and this is proof of service. This is what informs the clerk's office that the person has been served and the date of service. Once the defendant is served, a clock starts ticking that tells the defendant, or I guess the defendant reading the summons will figure out that he or she has a specified period of time to file his answer or whatever he planning to file in response. It is oftentimes 20 days. In Texas, It's not a certain number of days, but it's a little bit more complicated formula. You don't need to know that for this class. But in the federal system, it's 20 days. The most common response for the defendant to file is an answer. And an answer does exactly what it sounds like it does. It answers the allegations in the complaint. It responds to it. It may also include some cross-claims and counterclaims. Mary is suing Bob because of the car accident. Bob answers the lawsuit denying Mary's claims and then sues Mary because of the car accident. Or perhaps Bob sues the brake company that maintained his brakes. Brakes are us. A counterclaim would be suing Mary. A cross-claim would be suing someone else that Mary had sued already as a defendant. But sometimes the defendant doesn't file an answer and instead chooses to file a motion to dismiss. And, of course, I think it's pretty obvious. This is requesting the court dismiss the case for a specific reason. Obviously, the defendant would always love for the lawsuit to be dismissed, but the defendant obviously has to advance a reason for that. Oftentimes, a motion is going to include certain items. Not all motions have these items, but a motion to dismiss would likely. Obviously, there'd be the motion. Then there'd be a memorandum of law explaining, hey, this is why we win. It's going to cite statutes or cases, and it may well have supporting affidavits. Likely there will be a notice of hearing, a date that you often the paralegal, will have contacted the court's coordinator to find out what day this can be set for a hearing, and then a proposed order. A proposed order is what you want the court to sign, to say, hey, let's go ahead and dismiss this lawsuit. Of course, there's no guarantee that the court will sign it, but you're proposing it. Now, the motion to dismiss is oftentimes worked. The paralegal will work with the attorney on that, very likely helping get the supporting affidavits, getting them executed, noticing the hearing up, drafting a proposed order. More likely the memorandum of law and the motion will be prepared by the attorney, but not always. Here's an example of an answer. You'll see it really mirrors the complaint. It has the same type of caption. Then it has jurisdictional allegations and general allegations. Each allegation in the complaint will have a direct response in the answer if it's filed in federal court. That's not true in Texas state court. And then you can see that there's an affirmative defense section. That's a new thing that obviously you don't see in a complaint. It will be signed in the same way that the complaint is signed. If an affidavit is necessary, then you'll need to have the affidavit, but usually that's not required. And if the plaintiff hasn't requested a jury trial, then the defendant can at this point. Okay, scheduling conference. This is when typically the court enters the scheduling order. And this sets time limits for pleadings and for discovery. It establishes dates for pretrial conference and trial. And these are very theoretical dates. Don't necessarily mean that the trial will actually happen. But it's a kind of a way to set up a time frame for what the next steps will be. You may be wondering, well, why are we setting up time limits for pleadings when most likely, well, certainly the complaint has already been filed, and most likely the answer has been filed by this point? Well, it's true that the first round of pleadings have been filed, but it's fairly common for pleadings, both plaintiff pleadings and defense pleadings, to be amended. They may be amended because of new factual information or perhaps new legal theories. Keep in mind at the time period that the defendant and plaintiff have filed their answers and their complaints, they have not had the benefit of the discovery process. Okay, there are some other motions, well, there's lots of motions that can be filed, but here's a sampling of a few. One is a motion for a judgment on the pleadings. This is relevant when there are no facts in dispute, but the only issue is, well, what does the law say about this? In this situation, the judge considers the information of pleadings only. There's no need to refer to discovery. So imagine for a second I file a lawsuit that says I punched Bob in the nose for no reason. I just wanted to punch him in the nose. And when I punched him in the nose, I broke his nose, and his broken nose cut my finger, and I'm suing Bob about it. Well, Bob can file for a motion on the pleadings because given what I say, even if it's 100% true, there's no way I can win. There's no need for discovery because obviously I'm responsible for Bob's injury, and I'm also responsible for my own injury. A more common motion to file is a motion for summary judgment. In federal court, these are ubiquitous, very, very commonly filed. They are filed when they should be filed when there are no facts in dispute, when there's only questions of law. They are filed usually after discovery is closed or right at the end of discovery. In this type of motion, though, the judge can consider evidence outside the pleadings, typically evidence that comes from discovery. So let's imagine that you have a plaintiff in his deposition who has made some admissions that really undercut his argument or his complaint. Well, under those situations, those admissions in the deposition can be used by the defendant to as evidence to support its motion for summary judgment. And there's lots of other motions that can be filed, but those are just two. Let's talk about the 5 discovery tools. First of all, let's talk about what discovery is. This is formal investigation prior to trial. And when I use the word formal, I mean that this is court-ordered exchange of information. There's no way out of this other than settlement of the case. You've got to share information with the other side. Every instinct will tell you, you don't want to. But that's the way our system is set up. It's not the way all legal systems are. In fact, ours is somewhat unusual in having such an extensive discovery. But it's our system. We have to exchange the information. You have to tell the other side, but of course the good news is they have to tell you. So it's even from that perspective. And there's a set time period to accomplish this called discovery. So let's talk about the 5 big discovery tools. Interrogatories. You can see in the word interrogatories you have the word interrogate. And what is an interrogation but a question asking? Interrogatories are written questions by one party to another party to a lawsuit. This is important, the word party. You cannot ask interrogatories of non-parties. Let's say in that car accident that Bob is suing Mary about, Larry was walking by. Larry just happened to be at the intersection that time, doesn't know Bob, doesn't know Mary. Well, Bob might love to give Larry interrogatories, but because he's not a party, he doesn't have to answer them. They aren't interrogatories are not designed for non-parties. Why not? Well, they're pretty burdensome to have to research and answer all these questions. That seems not fair to somebody who isn't a party to litigation. So what happens when a party receives interrogatories? Well, they have to answer them in writing and under oath within the time frame specified by the court rules, which is typically 30 days. Usually the paralegal will work with the client to prepare the response to the interrogatories for the attorney's review. Another common tool are depositions. These are similar to interrogatories in that they do involve a question and answer format. But these are different. They're usually in-person questions and answers. They're still under oath, and they can be of a party, certainly, but they can also be of a witness. So Larry, the innocent bystander, it can be subject to a deposition. A subpoena may be necessary to get Larry to come, though, in a deposition because it counts as a court appearance in some sense because there's a court reporter present and the witness is put under oath. The questions have to be asked by the attorney, although the paralegal may have prepared at least the first few drafts of the questions. And the paralegal may prepare the deponent, may ask, assuming the deponent, when I say deponent, I mean the person who is going to be answering the questions. The paralegal may prepare the deponent for his or her deposition by explaining the process and going through some practice questions. And, of course, the paralegal may take notes and even suggest to the attorney questions that might be able to ask. Traditionally, the paralegal summarizes and indexes the deposition transcript after it's returned by the court reporter. Now, I'll tell you this is a very significant part of litigation paralegal job responsibilities at one point. It's less common now, though, because software exists that kind of do this automatically, or at least do a first run of the summary pretty well, and then the paralegal may want to clean it up. In addition to interrogatories or in depositions, there are also requests for production. This is production of documents, data, or even physical evidence. Then there can be requests for physical or mental examination. If the plaintiff is saying that he or she has a particular illness or injury as a result of the event, it may be that the defendant is not persuaded about that and wants his or her own physician to evaluate the plaintiff. That would be a request for physical examination. And finally, request for admission. This is when the either side can do this, can say, hey, we think these facts are true. We want you to confirm they're true. It's kind of like a true-false test, where the other side gives you statements and you either admit them or deny them. This is FRCP, stands for Federal Rule of Civil Procedure. Federal Rule of Civil Procedure 26 is designed to reduce the time and cost of traditional discovery. Number one, you do not need to know this rule number, so don't feel like you have to commit this. This rule was a change in the discovery process. It requires both sides make some initial disclosures. So the discovery process actually starts before either side has asked the other side any questions. Parties with discoverable information, the initial disclosures are you have to list individuals who have discoverable information. You have to describe all the relevant documents and data or things that might be in your control. You have to calculate damages, and you have to disclose insurance policies that may be applicable. So the goal here is that or at least intended to reduce some of the gamesmanship so that both sides know from the get-go they have to provide some of this information. If either side fails to disclose the information they're required to, either under Rule 26 or under the other rules relating to specific discovery tools, there can be serious sanctions, both under the Federal Rules of Civil Procedure and the Texas Rules of Civil Procedure. Another thing that happens under Federal Rules of Civil Procedure 26 is that a discovery plan is developed, and the attorneys for both sides develop a plan and submit it to the court. It includes the types of information that will be sought and the timetable for it. And then there's also the requirement that disclosures continue to be made. It may be, for example, that at the time that your side answers a request about expert witness designation, you may truthfully say, we haven't selected an expert witness. But let's say you select that expert witness 3 weeks later. Well, then you're required to supplement your answers to reflect that additional information. An example of a subsequent disclosure is expert witnesses. You have to disclose things like their qualifications, the opinions that they've developed in the case, and what they're being paid. You may also become aware of additional witnesses or exhibits. And as I said before, the attorney has an ongoing duty to disclose this information as quickly as practical after the information developing. The attorney can't decide on the expert witness, on July 1st, and then wait until October 1st to reveal that information. Electronic evidence, which is oftentimes called e-discovery, is a very, very big deal these days. It is very much of a growing area of the law. If you happen to have for both attorneys, I think I might not have been hitting the button for a second, so I'm going to go back and start talking about electronic evidence again. Electronic evidence, which is oftentimes called e-discovery, is a very, very big issue these days. It's really been a big issue probably for 15 years. With the growth in the storage capacity of computers and companies' tendency not to, or to continue to store information kind of forever, it has resulted in the expense associated with discovery to just skyrocket. And it has, I guess the good news, that might not be a good news from the societal perspective, but it's the good news for legal professionals, because if you have a technological bent, you can be very successful in this area using that information to be involved in the discovery. So let's talk about electronic evidence. This is all computer-generated or electronically stored information. And there's a lot of issues with electronic data. One is metadata. This is the information that is not available in printed form. For example, if you had a Word document and you were to print it out, all you would see would be the latest version. But if you had the metadata, you would know earlier versions, you would know when the documents were created, where they were stored, whose computer they were stored on, lots of additional information. And you can see how that metadata could be very important to figuring out what was going on in that particular situation. Another big source of electronic evidence is email. Email is becoming more and more a smoking gun type of evidence. People used to use the coffee shop in the business or whatever to chat about this or that thing, and they kind of let their hair down and say what they really thought. But nowadays, many times people use IM or emails for this purpose. And of course, these records are permanent. And so you say something casually to somebody, a joke, an offensive comment, something along those lines, not really intending it to be permanent or not thinking someone else can see it, and that document then becomes the linchpin of the other side's case. So huge, huge area of vulnerability many times for defendants. Many times deleted computer files are recoverable. They can be retrieved at least partially. And so even though you may have hit that delete button on the email, it doesn't mean that it cannot be restored. So let's talk about places that we might look for electronic evidence. Well, obviously active files, but also backup files and residual data from erased files that might not have been overwritten yet. But it's not restricted to that. It can be voicemails, electronic calendars, BlackBerries, all of those types of devices. There's a lot of different ways you can get electronic evidence. One goal often is to get an exact image copy of it. But do you want it in print form where you're going to lose that metadata? But it may be presented to you in an electronic format that is difficult to read. Maybe the technology of that electronic format is no longer readily available. Maybe it was defunct technology. So there's all kinds of issues about how that information is presented. You'll also want to show a chain of custody associated with it to know that you have an authentic version and that you're going to be able to prove that to the jury and be able to get that piece of evidence into evidence at trial. When you see the term FRE, that stands for Federal Rule of Evidence. This is, again, another category of procedural rules, kind of like the Federal Rules of Civil Procedure. Federal Rule of Evidence 502 means that the accidental release of protected information does not always result in waiver of the privilege with respect to that information. Typically, the protected information is going to be attorney-client privilege. Not always, but that's the most common path for that. A couple of notes. First note is you do not need to know number 502. And another important note is it's not always the case that accidental release protects you. You can still waive it, but there's a chance that you can still preserve it. Having said that, it's very, very important. One of the biggest functions of the paralegal when they're doing a document production is to make sure that you're protecting all privileged communication. When you're doing a big document production, you can have a room, literally, if you were to fill our classroom, from ceiling to floor, completely. There are document productions that are bigger than that, easily bigger than that. So we're talking about lots and lots and lots of pieces of paper. And it feels like a needle in a haystack, but it's important that you get all those right documents that are protected. Make sure you're not producing them. Okay, we're to the summary. All civil litigation involves similar procedural steps based upon federal rules and state rules of civil procedure. The first steps include the initial client interview, preliminary investigation, setting up of the litigation file. The plaintiff then files the complaint and serves the defendant, and the defendant responds, typically with an answer, but maybe with some kind of motion. Either party may file a pretrial motion, such as a motion for judgment on the pleadings or for summary judgment. But either party can, but most of the time it's going to be the defendant. There are lots of other motions that can and are routinely filed, but these are two examples of big motions, important motions. To prepare for trial, each party gathers information through the discovery process. Federal Rule of Civil Procedures require cooperation and automatic disclosure of certain information. Electronic evidence can be an important source of information during discovery. This concludes Chapter 9 of our text. You will have an opportunity to ask questions during one of our classes. I'll open it up. So if you have any questions, be sure to jot them down and bring them to class, and we'll talk in more detail about them. Thanks for listening. You're welcome to listen to this more than once if you think that would be helpful for you. Take care.